Mr. Paul.
Now the difficulty and the headings are order to item number 1. WCP number 4510 of 2021 is the responsible for the petitioner. Is the ombudsman or the respondent?
If it may please your lordship.
Yes.
Your lordship, the only surviving defect in this case is with regards to page number 66. It is a map, your lordship, which forms part of the lease deed. So I was typed copy of this page is wanting. I was only praying that this defect may be ignored, your lordship.
Okay. So this is also the same issue, this repetitions.
Yes, your lordship, this is with regards to royalty, service tax and royalty, your lordship. The Honorable Apex Court as well as this Honorable Court has passed interim orders, your lordship.
Right.
We have annexure 10 and annexure 11, your lordship.
Right. Because surviving defect is ignored on the request of Law and Counsel for the petitioner. Since page number 66 forms is a map. Page number 66 is a map part of
Lease deed dated 8/10/2015, your lordship.
lease deed. Annexure
1.
Please, annexure 1. Stop. फिर इसका भी ऑर्डर बाकी जो है ना आइटम 4 ऑनवर्ड्स उसके साथ जो कॉमन ऑर्डर होगा उसमें लिखते हैं. Very good.
Item 2. WCP number 4518 of 2021
This
Your
is also
lordship, as per our records, your lordship, in this case, as per our records, there are no surviving defects, your lordship.
page number 70. Handwritten. Page number 70 is handwritten. Page number 70 is handwritten. You find the type copy.
Your lordship, we have already furnished the typed copy of page number 70.
Then counsel for the petitioner submits that the typed copy of page number 70 has already been submitted. As such, the surviving defect may, there are no surviving defects. In that view of the matter, surviving defects, as per submission, accordingly, surviving defects have been cured. Office to verify. This one also service tax on royalty and GST.
Yes, your lordship.
Very well. इसमें भी साथ में करिएगा. और now from serial 4 onwards except 6 up to the last case, isn't it? 26. All of them are service tax and GST on royalty.
Yes, my lord. From serial number 7 onwards, my lord, I am appearing for the petitioners, my lord. All are the same matters relating of service tax and GST matters. Yesterday, my lord, through the email, I have forwarded 2 chart, my lord, separating the GST matter and service tax matters, my lord.
Okay. And apart from that, 4 and 5 are of Mr. Pasari's office. No, they are also
Yes, your
same.
They are also the same.
Yes, your lordship. Service tax on royalty.
So then, Ms. Jalan, your matters are both service tax and GST or only?
Only service tax, your lordship.
So 1, 2, 4 and 5 all only service tax?
Yes, your lordship.
Okay. Very well. Brother, इसमें common order?
Yes, common order हो जाएगा सर. Already किया हुआ है.
हाँ. तो आप भी अपना बना के भेज दीजिए मिस्टर पसारी एक चार्ट फॉर्म में जैसे गरुड़िया जी भेजे हैं.
We will do that, Niraj.
उनसे पूछ लीजिए चार्ट में है केस का नंबर, पार्टी का नाम, डिस्ट्रिक्ट, नोटिस का डेट और क्या इन्वॉल्व है.
We'll do it, Niraj. We'll do it.
So we will incorporate in the form of a short chart and then pass a common entry model.
Yes, Manoj. In half an hour it will be posted, Manoj.
Very well. तो फिर लिखिए सबको पहले तो टैग करिए.
Lordship, may I indicate one thing, Lordship, subject to kind permission of your Lordship, my Lord.
Yes.
My Lord, I will be also sending a fresh chart of GST matters, my Lord, because in some cases we have sought for a declaration, my Lord. So within 5 to 10 minutes, I will send a fresh chart relating to GST matter, my Lord.
Okay. So in some cases there is no notice, but you want a declaration that GST is not leviable on the royalty.
Yes, my Lord, yes.
Right. We have passed an order in the previous batch cases in one of the cases.
Yes, my Lord. I have also sent through mail that order, my Lord.
देखिए all these writ petitions raise common issues relating to levy of service tax and obligatory on royalty and district mineral fund. Contribution paid by the petitioners who are lessees in respect of minor mineral executed with the state of Jharkhand. Stop. For convenience sake, as such, they are tagged together. For convenience sake, the relevant details of individual petitioners with the period of service tax and obligor GST involved and the dates on which impugn notices have been issued upon individual writ petitioners, as also in some cases where the writ petitioners have not yet been served a notice but are seeking a declaration that GST is not leviable on royalty, are indicated in the form of a tabular chart here in below. So, Mr. Kushwaha, you also indicate in your chart the restrictions in which only a declaration is being sought.
Yes, my Lord.
Apart from other details, name, district, etc., and the, of course, period may not be involved, but same issue of declaration of the.
Yes, my Lord.
Then counsel for the petitioner submit that this court, in a batch of writ petitions led by WPP number 3878 of 2020, has been pleased to pass an interim order on 2nd March 2020 staying the recovery of service tax for grant of mining lease/royalty from the petitioners. Though interim protection so far as levy of CGST and or JGST is concerned was not granted. Stop. However, later this court has also been pleased to stayed. Payment of GST for grant of mining lease/royalty by the petitioners in view of the interim order passed by the apex court in the case of Messrs. Lakhvinder Singh versus Union of India and others involving same issues. In the batch of writ petitions led by WPT number 4609 of 2021, Messrs. Ratan Blackstone Sahibganj versus Union of India through Principal Commissioner Central GST and Central Excise Ranchi and other analogous writ petitions, while order dated 6 January 2022. एपेक्स कोर्ट का इंट्री ऑर्डर का डेट है 4 अक्टूबर 2021. Stop. Then counsel for the petitioners submit that since the issue involved in the present writ petitions are same, similar interim orders staying recovery of service tax and obligor GST may be passed in favor of the petitioners. So, learn counsel for the respondent state, you give your appearance slips in the respective writ petitions. Combined, do not seek and are allowed 4 weeks time to file counter affidavit in the respective writ petition. Any Union of India is there in these matters? And
Yes, ma'am.
Let's in our writ petition, we have made union as a party.
Very well. So, when counsel for the Union of India and the state, yeah, Union of India से तो बेहतर होगा CGST.
CGST as well, man.
Union of India, CGST, the state. Pray for and allowed 4 weeks time to file counter affidavit. Stop. 1 week time thereafter is allowed to the petitioners to file reply if so advised. Stop. Having regard, let the instant writ petitions be tagged along with WPT 3878 of 2020 and other analogous writ petitions. This court finds that by interim order dated 2nd March 2021, the passed in WPT number 3878 of 2020, the recovery of service tax for grant of mining lease/royalty from the petitioners therein had been stayed after consideration of the pleadings on record and rival submission of the parties in the following terms. ये कोट कर दीजिएगा para 14-15. It further appears that pursuant to the interim order passed by the apex court, interim order dated 4th October 21 passed by the apex court in writ petition civil number 1076 of 21. In the case of Messrs. Lakhvinder Singh versus Union of India and others, wherein the apex court had stayed the payment of GST for grant of mining lease/royalty by the petitioner till further orders, this court has also passed an interim order in a batch of writ petitions led by WPT number 4609 of 21, staying payment of GST for grant of mining lease / royalty by the petitioners until further orders. Stop. Accordingly, the case of the present petitioner shall also be governed by the interim orders passed in these respective cases. Stop. Until further orders. It is while the revenue is not restrained from conducting and completing the assessment proceedings until further orders, recovery of service tax and GST for grant and or GST for grant of mining lease / royalty from the petitioner shall remain stayed. साथ में लिस्ट करने का ऑर्डर. Very good. So give the chart, revise that. तो ये 1, 2, 4, 5 और 7 से लेकर लास्ट तक. तो सबका चेक भी कर लीजिएगा. लीगल असिस्टेंट के साथ बैठ करके प्रेयर पोर्शन.
My lord, in item number 18 and 26, my lord, my appearance, my lord, if can be recorded, my lord.
I already said, please send your appearances along with your DCs.
My lord.
Now, learned counsel, should we hear these matters finally after the pleadings are complete, or should we wait for the outcome of these cases before Supreme Court?
But since the same issue is there before the Supreme Court with regard to service tax as well, I think we can. So it would be appropriate if we can wait for some time.
No. Obviously, it is not going to be heard immediately because pleading in another this batch of writ petitions would also get completed.
Yes.
But whether it would be profitable to deliver our opinion first or wait for the apex court to decide it finally. I'm just posing a question. In that case, the apex court often has the benefit of the opinion of one high court or one or two high courts, either way. And we also get to enrich ourselves by the
Absolutely.
Legally, my lords, there is no bar in law if your lordships are not precluded from hearing these cases only on the ground of pendency of the SLPs.
True. We heard similar matter in the entertainment tax case in 2014.
Yes.
And we delivered a good judgment. Of course, that issue, perhaps is still pending, that entertainment tax issue, PGST, this service network providers were challenging that. So we can think of it. We have still time. Councils may prepare themselves. Maybe in an opportune time we can hear it, because in the Supreme Court it may not be heard, and the question is of payment of some revenue to the state. So keeping it in a way for a very long time across the country, maybe because of the apex court, we may decide it one way or the other. This may be one approach. Think over it, learned councils, think over it.
Yes.
My lord.
In fact, you can make a compilation, etc., of all the common issues and then decisions and short notes. In the meantime, you have got plenty of time. Maybe sometime in April, May, we can hear it.
Yes.
That would be a good judgment because this is a very seminal issue.
Big issue, my lords.
Okay then.
Much
Obliged, my lords.
Obliged, my lord.
3 or 6 minutes.
Already
6 you have?
27 for the answer for the because I will for the
My lord, may I please?
Yes.
Lord, this matter is very small issue has been raising, my lord. Lord, where annexation number, my lord, page number 116 is under challenge, my lord. Whereby, my lord, my writ application was basically dismissed, my lord, on the ground of, my lord, efficacious remedy of appeal, my lord.
Right.
Please place the inquiry in order, my lord, at page number 116, my lord.
So this is short order,
Yes, my lord.
and basically the settlement has been cancelled by the deputy commissioner. So
Yes.
if the appeal lies before the commissioner,
My lord, this is the only issue, my lord, which is required to be answered by this honorable court, my lord. My lord, the deputy commissioner is the appellate authority. He has observed the jurisdiction of the learned LRDC, my lord, who is having the jurisdiction under section 4H, my lord. And my lord, the appellate authority is the deputy commissioner, and thereafter divisional authority is the commissioner, my lord. My lord, kindly have, my lord, section 2E of the BLR Act, my lord. Section 2E, my lord.
no, have you extracted that provision in your memo or?
No, my lord, I have not extracted, my lord. I have not extracted, my lord, that provision, my lord. Kindly have section 2E, my lord, which defines, my lord, the collector. Bihar Land Reforms Act.
Which section?
2E, subclause E, my lord, section E.
2E.
My lord. My lord, it defines, my lord, collector.
Just. Collector.
Yes, my lord. May I please, my lord. Collector includes any officer not below the rank of sub-deputy collector appointed by the state government to discharge all or any of the functions of the collector under the act. Now, my lord, may kindly take section 4H for a moment, my lord. Four H, my lord, small h.
Yes, yes.
May I please, my lord?
Just a minute.
I'm sorry, my lord.
Yes.
May I please, my lord? The collector shall have power to make enquiry in respect of any transfer, including the settlement or lease of any land comprised in such estate or tenure or transfer of any kind of interest in any building used primarily as an office or kachari for the collection of rent for such estate or tenure or part thereof. And if he is satisfied, not he is very important, if he is satisfied that such transfer was made at any time after first day of January 1946, not sure here is important, with the object of defeating any provisions of this act or causing loss to the state or obtaining higher compensation thereunder, the collector may, after giving reasonable notice to the parties concerned to appear and be heard, annul such transfer, dispossess any person claiming under it, and take possession of such property on such terms as may appear to the collector reasonable, fair, and equitable. Now, my lord, provided, here is important, lord, here is my case. Provided that an appeal against an order of the collector under this clause, if preferred within 60 days of such order, shall lie to the prescribed authority not below the rank of collector of a district, who shall dispose of the same according to the prescribed procedure. My lord, now, my lord, kindly take section 4 capital A, my lord. 4 capital A.
Revision.
Yes, my lord. The commissioner of a division, my lord, this is the divisional authority. The commissioner of a division may at any time call for and examine the record of any proceeding under section 4 under clause H or clause HH for the purpose of satisfying himself as to the correctness, legality, and propriety of the findings or the orders. Lord, therefore, my lord, in my humble submission, the order passed by the deputy commissioner was without jurisdiction. The original power vested with the learned LRDC to decide the provisional section, because of which I do not have any quorum to prefer any appeal. And moreover, my lord, sorry,
Impugned order. Where is the impugned order?
my lord, impugned order, my lord, is at page number, starts from page number, my lord, 87.
87.
If my lord, I may insist, my lord, to kindly take page number 79 first, my lord. Page number 78 or 78 or 79, whatever, my lord. 79, my lord. This is the, sorry, my lord.
79.
79. Lord, I'm reading the relevant portion only, last two paragraphs. संबंध राज्य कर्मचारी एवं अंचल निरीक्षक द्वारा पंजी 2 के पृष्ठ संख्या सोवेंसो मौजा टेंडर इंद्र कुमार तिवारी पिता सोवेंसो खाता संख्या इतना 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 एक का जमाबंदी एक पृष्ठ में संदिग्ध माना है। उक्त उपरोक्त तथ्यों के आलोक में मौजा सोवेंसो खाता नंबर इतना 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 झारखंड भूमि सुधार अधिनियम के विविध प्रावधानों के आलोक में अग्रतर कार्रवाई हेतु अनुशंसा की जाती है। लॉर्ड्स काइंडली मेक अ नोट, अभिलेख अग्रतर कार्रवाई हेतु अपर समहर्ता भूमि सुधार को भेजी गई। Now, my lord, I'm sorry, my lord.
Yes.
My lord, this was forwarded to the LRDC, my lord. The circle officer forwarded to the LRDC. My lord, next annexure number 12, page number 80. My lord, kindly take page number 81, my lord. Last line, my lord. अभिलेख अपर समहर्ता रांची को अग्रतर कार्रवाई हेतु प्रेषित की जाती है। My lord, he thereafter referred the matter to the additional collector. Now, my lord, may kindly take page number 84. Lord, very last line, page number 84, my lord.
Yes.
अतः अभिलेख उपायुक्त रांची को अग्रतर कार्रवाई हेतु भेजी जाती है। He again referred to the, my lord, the deputy commissioner. My lord, thereafter, my lord, the impugned order at page number 87 has been passed. My lord, may kindly take page number 87, my lord. The entire facts have been narrated. My entire claim has not been denied, my lord. And my lord, kindly have the operative portion, my lord. The findings, my lord, at page number 94. My lord, entire my case has been narrated. My arguments has been, whatever judgments have been started, everything has been dealt with. My lord, now the operative portion at page number 94 may kindly be seen. Has the lordship got that page 94?
Yes.
Only one paragraph finding, my lord, nothing else. May I please, my lord?
Yes.
Yes, having, my lord, para number 2. Having heard both the parties and on perusal of the materials available on record, I find that the transfer of lands of khata number so and so area itna 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 acre has been transferred by the ex-landlord in favor of Indra Kumar Tiwari on 1/1/19 after 1/1/1946 for defeating the provisions of the act, causing loss to the state and to obtain higher compensation. Hence, the settlement made in favor of Indra Kumar Tiwari is hereby cancelled. As per the recommendation made by the learned additional collector Ranchi, Sadar Ranchi, and the circle officer and Kake Anchal, demand with respect to lands of so and so is directed to be cancelled. My lord, only one paragraph. There is absolutely no finding as to what was the whether any loss was caused to the state or not. My lord, I have purchased this property in the year 1948 by virtue of registered deed, my lord, which is part of annexure number 1 to 6. Thereafter, my lord, I paid Jamindari rent receipt, my lord, which my lords may kindly find at page number, annexure number 7 onwards, my lord. Annexure number 7 may kindly be seen, my lord. This is the page number 61. Page number 61, my lord. These are the Jamindari rent receipts, my lord, which were issued at that point of time, my lord. Page number 61. My lord, all the entire rent. Thereafter, my lord, may kindly find the state government opened Jamabandi in my favor, my lord. Jamabandi was opened in the 1956, my lord, after coming into force of the Bihar Land Reforms Act. Page number 67.
Let us not get into the merits of what
Yes,
inquiry.
My lord, there is one authority also in this regard, my lord, if my lordship so pleases, my lord, may I place, my lord?
It is represented by.
Yes, Lordship. Mr. Piyush Chitresh is on with in court number 1 assisting learned advocate general, Lordship. I will be there. Lordship, as the learned single judge has already stated in the judgment, Lordship, that he has an alternative remedy that he can prefer an appeal before commissioner, not for Nagpur division, Lordship. as per the fact, I would pray for some time, Lordship, for filing specific counter affidavit in this matter, Lordship.
This is not a healthy practice that you are picking up. This is an appeal. In appeal, where is the question of asking for counter affidavit?
My lord, counter affidavit is already on record, my lord.
Already on record, and there is no plea of alternative remedy taken in that counter. Have they taken any plea
No,
of
no, 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 my lord, no, my lord.
No, Lordship, that was not taken
during
place.
course of submission before the writ court? The State Council said that there is an efficacious remedy. Please show us where is that efficacious remedy. Mr. Sushant Kumar, to assist the court before a division bench,
Yes.
show us the provision under which he can prefer an appeal against the order of the Deputy Commissioner himself.
My lord, there is a my lord, the judgment from our division bench also, my lord, in this regard, whereby, my lord, it has specifically been observed, my lord, that the LRDC is not the recommending authority but the adjudicatory authority. This is the specific line, my lord. Our division bench, my lord, has observed, my lord.
State has been passing orders from time to time since the creation of this Bihar Land Reforms Act. So they know where the Deputy Commissioner has the power, original power, and whether appeal lies. Show it to us.
Lordship, I will find a specific counter affidavit, Lordship. There is not.
Yesterday also we noticed that you are appearing unprepared, and just when asked you are asking for a time to file counter affidavit.
My lord, my Jamabandi is running since 1956. My lord, 2021 I paid rent, my lord.
This is a simple issue. If there is no remedy of appeal, then we will remand the matter to the writ court. Writ court will consider it. On your submission, State's Council submission, the writ court refused to entertain the writ petition on grounds of maintainability. Now don't go off this plea.
Lordship, a short time may be given, I would take a specific instruction, Lordship.
When the opportunity comes up, then you seek more time. Today is the time.
And my prayer was this only in the LP only. I have made a specific prayer in this regard only, that no jurisdiction, my lord, to pass an order.
You are not prepared, then we will ask the Commissioner himself and the Commissioner to assist the court.
Lordship, 1 week time may be given, Lordship, I will.
Deputy Commissioner must be passing orders exercising 4H powers. The point is whether an aggrieved person will have a remedy of appeal against that order, or he will have to, having no other statutory remedy, he will have to come to the writ court. So why this practice has been followed, that instead of the LRDC or additional collector, the deputy commissioner has been passing orders. We need to understand it's not a one-off kind of a thing. Must be happening from before, and there must be cases decided also.
Lord.
There might be some delegation under the Act.
Lord, I am referring to 2021 judgment, my lord, of our High Court, and 1989, my lord, the Patna, the Ranchi bench, my lord.
Have you sent the citation?
My lord, I have sent the judgment also, my lord. May I please place, my lord? Lord, I am placing, my lord, 2021 volume 2 AJR 539. My lord, this is the division bench judgment, my lord. My lord, may kindly take page number 545. 545. My lord, this is state of Jharkhand versus Izhar Hussain, my lord. My lord, this state government has also challenged before the Honorable Supreme Court, and this judgment was affirmed, my lord. My lord, page number 545.
545. We have an email containing that judgment. Which paragraph of that judgment are you?
My lord, has lordship got page number 545?
No, this is a
My lord, this is state
judgment.
of Jharkhand versus Izhar Hussain, my lord.
Right, right. So it is the pages are in chronology starting from page number 1. There is no page 545.
My lord, may at the very top, my lord, may kindly see in 545, my lord. My lord, once minute. Yes, my lord. My lord, may kindly take. Has the lordship got page number 545 or page number 10? Where my or my lord, in the bottom of the page, my lord, lordship may kindly find page number, my lord.
Yes, that is page number 1,
Yes.
8, 9, 10.
Yes, sorry, my lord. Sorry. Page just above para number 17, my lord. May kindly see para number 17. Lord, just
Yes.
bottom of the page, page number 6.
Hmm.
Just above para number 17, my lord.
Yes,
Further,
yes.
further, it is the case of Shri Rama Prasad Singh and others versus State of Bihar, as reported in so and so. It has been held that the annulment of settlement made in 1945 on assumption that it was made within the family to deprive the valuable land is mere assumption. On the plain reading of the provision, it is obvious that the collector, while exercising powers to make inquiry in respect of any transfer, must be satisfied that such transfer was made at any time after 1st January 1946. No finding recorded at the recorded that the trans that the trans that sorry that the transfer was made after 1st January 1946. Lord, here is the issue, my lord. The land reform deputy collector, being an adjudicating of body, could not recommend such annulment and had arrived to its own conclusion in terms of section 4H of the Act. And my lord, there is one more authority, my lord. If my
This,
lord,
this judgment is not on the same facts that the collector or the deputy commissioner has passed the order.
yes, my lord, there is one more authority. There is only a reference to that regard, my lord. If lordship so pleases, my lord, may I place one more judgment, my lord, directly in this specific issue, my lord. My lord, this is 1989 BLT, my lord. 1989 BLT.
You have forwarded that also.
Forwarded also, my lord. That also has been forwarded, my lord.
That is last. So,
Lord,
single
this is a. I'm sorry, my lord. This is a part that is a learned single judge judgment, my lord. I'm placing, my lord. Para number 8, my lord. May I place, my
Yes.
lord? In CWJC number so and so, it was held that before exercising the jurisdiction under section 4H of the Act, the learned LRDC had himself to be satisfied and arrive at its own conclusion that the transfer was made with the object of defeating any provisions of the Act or causing loss to the state or obtaining higher compensation thereunder. On the plain reading of the provision section 4H of the Act, it is obvious that the collector, while exercising his power to make inquiry in respect of any transfer, must be satisfied that such transfer was made at any time after 1st January 1946. My lord, no such finding appears to have been recorded in the present case. Here also, my lord, no finding. LRDC is an adjudicating body and therefore he could not recommend such annulment which is so obvious from the order. The court also failed to consider the fact that the state had accepted rent from the petitioner and did not prefer any appeal against the order of mutation made in his favor. As already held, LRDC cannot be a recommending authority. He is an adjudicating body and has to arrive at its own conclusion in terms of Section 4H of the Act. In the present case, there is no evidence worth to hold the settlement was made after 1146. My lord, therefore, in my humble submission, my lord, the LRDC is the original authority. Thereafter, against the order, my lord, if anyone is aggrieved, my lord, they can prefer an appeal before the deputy commissioner, my lord. And against that order, there is a provision for revision, my lord. And thereafter, my lord, the writ court. My lord, here, my lord, the circle officer recommended to LRDC recommended to additional collector, additional recommended to a deputy commissioner. Now, my lord, there is no forum of appeal left for me, my lord. Therefore, my lord, we have preferred writ petition. The same was dismissed on this court.
Yes, State Council, you reply to this specific.
Yes, Lordship, I will reply.
We'll keep it on Monday. You reply and we will take a decision.
Yes, Lord.
Learned counsel for this, learned counsel for the appellant, Mr. Shashank Sekhar, submits, relying upon, relies upon Section 2E, which defines collector. Section 4H, proviso in particular, and Section 4 capital A, revision of the Bihar Land Reforms Act 1950, to submit that the appellant has not been left with any remedy of appeal, since the Deputy Commissioner Ranchi has himself passed the order impugned in the writ petition dated 8 January 21, Annexure 16, cancelling the settlement made in his favor. Stop. Learned single judge has erroneously relegated, in such circumstances, the learned single judge has erroneously relegated the petitioner to avail of the alternative remedy of appeal when no such appeal would lie if the original order has been passed by the Deputy Commissioner himself. Stop. Then counsel for the appellant has relied upon decisions, relied upon the cases of State of Jharkhand and others versus Izhar Hussain, reported in 2021. AIR online 2020, J 1217. And also a single bench judgment of the Patna High Court, reported in the case of Sri Rama Prasad Singh and others versus State of Bihar and others, reported in 1989 BLT within bracket REP.87. Then counsel for the state seeks short time to answer the only legal issue raised in this appeal as above. The stop. As prayed for, matter be listed on 7th March.
My lord, if it could be in February, my lord.
Huh?
February.
Sorry, I am sorry. 7th February.
7th February.
7th February. We will not grant any further time, Mr. Sushant.
Yes, yes.
You are in the office of Advocate General.
Yes, Lord, sir.
So, either be prepared or request the learned AG to appear and assist the court.
I'm deeply obliged, my lord.
Yes.
Item 6, WPT number 4566 of 2021, the chronometer for the petitioner.
Yes, on the last day, they were asked to file a counter affidavit. Kindly see the order dated 11/1.
Yes.
11/1/22, they were asked to file a counter affidavit within 2 weeks. Because there's no facts involved, it's only a question of interpretation of section 1889. It's a pure question of law, and I don't think any counter also is required for that. He cannot take instructions from the chairman of the Commercial Tax Authority Tribunal and file a counters to why he has passed that order. It's a pure interpretation. Because I am a trader, I am not a manufacturer at all. I have annexed by way of annexure 1 Melots, my registration certificate. I am a trader. And section 1889 is
Mr. Pati.
Lord, I have sent an email with a request for adjournment. Only one opportunity, I'll file the counter affidavit.
So your stand before the tribunal was also the same.
my stand.
No, his stand states.
If your lordship sees page 20, paragraph 23, what the tribunal has held, that if it is manufactured, I'll just read that part of the order which I have quoted at page 20, para 23. It says, para 23, this provision of law does not mandate that the goods should be used by the dealer as raw materials for manufacturing purpose. The intent, we cannot see the intention. The intent of the legislature appears to be that such goods are likely to be used as raw materials for manufacture. Because then no good would ever get any ITC. Anything can be at a later stage manufactured. Here I am selling in the same form the used batteries I am purchasing from within the state of Jharkhand, and I am selling it outside the state of Jharkhand. What happens ultimately to those batteries, because I do not know. It is for the persons who purchase it, because even scrap sale are 3 to 4 to 5 stages before anything happens. So, so far I am concerned, I am selling it in the as it is condition. I am not even registered as a manufacturer. So, what will happen in future, we don't know. And neither in the assessment order nor in the appellate order, any authority has alleged that I am manufacturing. In both the orders, they say that I am.
1889.
Yes.
Is it? In respect of.
In respect
This
of
relates
page 26.
relates to which assessment year?
Assessment year is 12-13.
Financial year.
Financial year 12-13.
After 2011 amendment.
Yes. Now it says, in respect of goods used as raw materials in manufacturing of processing of the goods. So I'm not a manufacturer. If I don't manufacture, it's a straight interstate sale. This 1889 applies only where you buy certain goods, you manufacture, and then you send it to this. Then proportionate VAT may be given. But when I'm straight away buying something and selling it as it is, and I'm not a processor, I'm not a manufacturer.
Which is the page number where this finding has been given by the learned tribunal?
Yes, please.
Page 76.
I'm just telling lorships. Just 1 minute.
Page 83.
Page 83.
Page 83. Top, second line. Second line.
Second line. Should be used by the dealer as raw materials for manufacturing purpose. The intent of the legislature appears to be that such goods are likely to be. That is not in the section.
Where are you reading?
Page 83, second line from the top.
Page 82.
It starts from page 82 bottom. Let me start from page 82 bottom.
Internal page, para 20.
Yes, 20. Let me start from para 20. Now comes the most important aspect of the case, which relates to interpretation of the provision of law, that is section 1889 of the JVAT Act. The provision is quoted. In respect of goods used as used as raw material in manufacturing or processing of the goods for interstate transfer of stock or for sale outside the state. To my considered view, this provision of law does not mandate that the goods should be used by the dealer as raw material for manufacturing purpose. The intent of the legislature appears to be that such goods are likely to be used as raw material for manufacturing or processing of goods for the purpose of interstate transfer or sale outside state. It cannot be disputed that the scrap batteries, as is claimed to have been purchased by the petitioner, can be used only for the purpose of manufacturing or processing of goods, and therefore, to my considered view, the claim of the petitioner is within the ambit of section 1889 of the JVAT Act, and therefore proportionate input credit was allowed in terms of. Because I really fail to understand what the
What is the finding of the AO on this?
Yes, annexure 2.
Page?
Yes, I'm giving the page. Page 30 starts from page 35.
35 is important.
And the first two lines are important at page 35. First two lines. आलोच्य कंपनी बैटरी एवं एक्सेसरी सोलर पैनल, सोलर लैंटर्न, सोलर बैटरीज इन्वर्टर के विक्रेता है. This is what I want to emphasize. विक्रेता. I am a seller. I am not a manufacturer.
Yes.
Then at the next page, 4. इनपुट टैक्स क्रेडिट का दावा.
Yes.
आलोच्य कंपनी द्वारा राज्य अंतर्गत निबंधित व्यवसायियों से आलोच्य अवधि में विद इन द स्टेट अवधि में क्रय परचेज किए गए माल मूल्य 6 करोड़ 12 लाख पर 5% की दर से चुकाई गई वैट की राशि 30,62,285 रुपए दर्शाकर आईटीसी का दावा किया गया है. दावा के समर्थन में 31 अदर जेवैट कुल 6,04,50,246 का दाखिल किया गया है. प्रपत्र जेवैट के लिए वैट की राशि 29,33,668 दर्शाई गई है. So we claimed only that much, 29,33,666. परंतु यहाँ उल्लेखनीय होगा कि व्यवसायी द्वारा राज्य अंतर्गत क्रय किए गए मालों को अंतरराज्यीय स्टॉक ट्रांसफर वास्ते 2 करोड़ 28 लाख etc. का किया गया है. Now he doesn't specify which goods, because what I am stock transferring is air conditioners and not air conditioners, batteries and all that scrap. अतः प्रस्तुत दावा पूर्णतः अनुमान्य नहीं होगा तथा झारखंड मूल्य वर्धित अधिनियम की धारा 1889 के प्रावधान के अंदर portion part. Now he does not say even here that I am a manufacturer. Only he mentions 1889. He doesn't say that why he is invoking 1889. The necessary facts are also not here as to what is the reason that he is invoking 1889, whether there was any inspection, whether anything has happened, nothing like that. And similarly, Manos, the appellate authority, his order starts at page 38, and the relevant is at page
42, running page 42.
So you were paying 29 lakhs and odd
yes,
against the JVAT 404 that you had submitted in smooth.
yes, yes.
It allows 14 lakh 63,627 only.
So he disallows 14,63,627 and no reason is given. He just says, he just says,
Understand that he allows 14 lakh 63,000 and odd, and why he disallows, why rest of the JVAT, that he doesn't say.
That's right, that's right. He just mentions section 1889, but why he invokes 1889, he does not say that.
He doesn't say that those scrap batteries were in fact used for manufacture in an interstate transfer by him.
Yes, he should have said that.
Therefore, it is being denied.
That's it. If that would have been the case, that would have been his case, then it's a different thing.
We had no case.
Then we had no case. If we would have somehow or the other established.
Pati, you have defended it throughout up to the tribunal. You need to file anything on record to bring it on record, or you can argue on the basis of the materials on record.
But since I've received instructions from my clients, my lord, I was only praying for short time to file the counter affidavit. So it may be fixed on some other day. By that time, it is not filed. Your lordship may hear it on the basis of the material available in the writ petition. In that case,
We can keep it on next Thursday. You file it by Monday.
Very, very good.
one more day, my lord, if thereafter, because tomorrow is the last working. Thereafter, 5th is closed. Offices are closed on 5th and 6th. So I will only have two working day to file it, my lord.
5th is the first Saturday the court
I mean, 5th for the reason of Saraswati Puja, sir. Saraswati Puja.
Yes.
Because field offices are open on Saturday. Otherwise, I will not have time to file it. 14th, if it is kept on 14th, 15th, any day, my lord, subject to your lordship's convenience.
Very well, 14th.
Obliged.
Okay.
Can it be on 15th, 14th? Lots of cases already have been fixed. So 15th.
Yes, madam.
Or I leave it to the court. Any day is fine. I can just take a short pass over and come back again. If required. Let it be on 14th. No issue.
15th.
Very well.
Obliged.
And counsel for the state, Mr. Pati, prays for one more indulgence to file counter affidavit. For the petitioners, Mr. M.S. Mittal Singh, advocate, assisted by Mr. Rahul Lamba. Stop. As prayed for, 1 week more time is allowed to file counter affidavit. Today is 3rd, so by 10th. Let the matter appear on 15th February. You will be filing some rejoinder also, perhaps, in case there is some assumption on facts.
I'll file my rejoinder within a couple of days. As soon as by 15th positively, if he files it by 10th, then by 14th I'll file it.
No, then we'll ask him to file it by 9th, so that
Yes. I'll file it before 15th if required.
affidavit be filed by 9th of time as prayed for is allowed. Let counter affidavit be filed by 9th of February 2022. Stop. The case be listed on 15th February 2022, so that petitioner, if so advised, may file reply thereto well in advance.
Yes, we'll do that.
Very well. We have finished the board today, no?
I think we can from the next week, maybe perhaps some hearing matters can also be started if the board is over so early.
No, board gets exhausted because of the batch matters, and otherwise
Yes.
limited number of cases are being listed. That's the
Yes. That's then what I do, what I propose to do, that some old matters which are pending for admission, I'll be filing my slips for that.
We are gradually listing matters
Yes.
on mentioning or as per chronology also.
I think within 3 to 4 weeks, Lordship, everything should hopefully be normal. By the first week of March, maybe the court may open physically as well.
We had enough of experience of this. So
Yes.
go ahead.
Enough of this COVID now. This has to end now.
Rest of life goes on except our court. That should also not be there.
Very well.
Very well, brother.
Okay.